Good evening. Welcome to the August webinar of the Asian American Scholars Forum. My name is Zhenmen Gao. I'm a professor of chemistry at Boston College. I'm also serving as the president of the Chinese American Chemistry and Chemical Biology Professors Association, abbreviated as CAPA. CAPA is proud to be a participating organization and a co-organizing organization of the AASF webinar series. The AASF webinar series was initiated under special circumstances to invite and host political leaders, government agency officials, and legal experts and experts of other areas as well, to really promote mutual understanding between the researchers community and the government agencies, and particularly the Asian American researchers community. So, and we are, as the president of CAPA, I'm proud to be part of this effort, and CAPA is proud to be the co-sponsor of today's webinar. And a quick announcement before I introduce today's speakers. This webinar is recorded and is live streaming on YouTube, and the edited version will be made available on the website of the AASF and on YouTube as well. So back to the main topic. We are so excited to welcome Attorney Grayson Yeargin from Jones Day to speak with us today about export control. Export controls shouldn't be a unfamiliar terminology to this audience. I have to sign forms when I hire international postdoc fellows, and I have to sign forms when I purchase instruments. So would love to learn the intricacies about export control laws today with the experts. So a quick introduction about our speaker. Grayson received his JD degree from Georgetown University in 1999. He's now a partner at Jones Day, and he's expert in government regulations, particularly in cybersecurity, privacy, and data protection technologies. And his practice concentrates on assisting clients with compliance with government regulation, government requirements, and guiding them through government investigation. A significant portion of his work involves cases that concern economic sanction and export controls. So in addition to our speaker, we're also very, very excited to welcome Mr. Jenkins from Princeton University. John received his master's degree in international affairs from George Washington University, and he currently serving the role of the assistant director of export controls at Princeton. So John has more than 2 decades of experience in international trade and compliance in industries ranging from high tech to agriculture to academia. At Princeton, he oversees the university's efforts. He oversees the university's export control program and is active contributor to teams charged with supporting the university's overseas collaboration and research activities. So we look forward to the speaker and the moderator's discussion. Before I turn the forum to John and Grayson, I would quickly also like to welcome the panelists of today's webinar, which consists of leaders of the Asian American Scholars Forum, as well as the participating organizations. And more importantly, I would like to highlight that we have 2 special guests today. One is Mr. Jay Brett, who is the chief of the counterintelligence and export control section at the Department of Justice. And the other guest, distinguished guest, is Professor Maggie Lewis from Seton Hall University. Both Jay and Maggie shouldn't be, again, unfamiliar to this audience, because Jay and Maggie gave earlier webinars of this AASF forum series and contributed to additional webinars as well. So we really appreciate all of your contribution and help with the mission of the AASF webinar series. Welcome to all. We look forward to today's discussion. Now I'm going to turn the forum to John and Grayson. John?
Thank you very much, Professor Gao. Good evening, everyone, and welcome to the Asian American Scholars Forum. I am really excited about tonight's session, where we'll be discussing U.S. export control regulations and the aspects of those regulations that are most important to researchers. I have no doubt that we will all benefit from our speaker's extensive knowledge about U.S. export control regs and how those regulations apply to academic research activities. Now, tonight's session will include a presentation by Grayson, and then we'll move into a question and answer portion where I and the other panelists will do our best to present your questions to Grayson. So please feel free to submit your questions at any time during Grayson's presentation. He has graciously agreed to try to field those questions as the presentation goes along. Just to reiterate Jan Min's advice, please exercise care in framing your questions and refrain from sharing confidential or otherwise sensitive information during the presentation. We are fortunate tonight to have Grayson Yeargin of Jones Day Law Firm here to talk to us about export control regulations and how they apply to our research activities at our institutions. In addition to academic clients, he represents companies in the national security and defense industries, various government contractors, private companies, as well as individuals. Grayson's been in private practice for more than 20 years, 15 of which have focused on assisting organizations with export control and international trade compliance issues. He assists his clients with conducting internal investigations, assessing disclosure issues, resolving disputes with government agencies, and of course, defending clients in litigation. So welcome, Grayson. The floor is yours.
Thank you, John. So really looking forward to talking with everybody today. So thanks for having me here. As folks have mentioned so far, we're going to be talking about export controls in the research setting. And just a little bit of information before we jump into my PowerPoint presentation here. This is a very, as most folks know, this is a very complex area. So what I'm going to be giving tonight is going to be more of a high-level overview of the key issues and how they really intersect in a research environment. But really, we're going to be very much scratching the surface of what is in these regulations and laws. The presentation and the slides that I'm going to be showing should not be used as a substitute for the law itself. And just you know, the disclaimers lawyers always have to make. You know, this presentation doesn't constitute legal advice. And these are my personal views and not necessarily the views of my firm as we go through this. But let me go ahead and get into the presentation here. You'll see that there are going to be slides and we're going to go a little bit slower in the beginning and then speed up more as we go through. And let me just give a little primer on export controls as we go through this. Because I think I was talking with John before this, and we both think it's important to note that these laws have been around for quite a long time, decades even. They really started in their modern form back around World War I with the Trading with the Enemy Act. But they didn't really start taking the shape that they're in now until at least you know, World War II or during the Cold War. Where they really started to pick up and take on a lot more steam, especially in connection with the struggles with the Soviet Union. In the 70s, though, that's really where they started to look like what we have here today, where we're starting to see the export controls mixed into, split up into dual use restrictions and also into military restrictions. Some may recall that here recently there was some laws that were passed in 2018, the Export Control Reform Act. That really just solidified what was already in place and what has already been in place since the 70s as far as the export administration regulations are concerned. So these are not new laws, but especially here lately with the United States increased tensions with China, they've taken, you know, a much larger role in our day-to-day activities. So that's really what is bringing, I think, the focus here today. And why they are so important in what we're talking about. One thing to keep in mind as we talk about export controls is their focus. A lot of times everybody lumps export control or export and import together, but they really are very quite different. Export controls are focused on national security. They're focused on what is it in this country that we want to control that we don't want to get out of this country. As you might imagine, there's a lot of concern about weapons, sensitive technology, computer technology, short supply issues, things that can be used for human rights abuses. But at the end of the day, these laws are trying to strike a balance between control of what we think is dangerous and important versus business interests to try and not hamper companies from being able to do international trade. And then also what's more important from a research setting is making sure that open research and the open exchange of ideas can continue. So as you can see today with the outline in the slides, we're going to start with a little background on the export controls, going through some of the key concepts and basic issues. Then we're going to talk about some scenarios and exceptions that are really very important for the research setting. We're going to talk about sanctions because you really can't have a full discussion of export controls without talking about sanctions. And then we're going to talk about some of the more recent actions and where I think things may be going in the future as we go forward. So let me get started here. All right, so these are some key concepts that are really important to understand as far as what is being controlled for export. And it seems like we're starting at the beginning, we really are. And these ideas show, or these concepts show the breadth of these laws. And they also show how the laws have had to expand and change over the years to close loopholes that may have come up as the laws were put in practice. But the export is very basic in sending anything outside of the United States. Re-export is the idea of sending something out of the United States and then having it go from one non-US country to another. A transfer is if an item is in another country and then it goes to a different end user or takes on a different end use. That's a controlled activity as well. And a deemed export, and this is a surprise to a lot of folks who are first learning in this area. It's a controlled activity that happens completely in the United States. It is an in-country transfer or release of a controlled item or technology to a non-US person completely within the United States. So here on this next slide, we're going to talk about a little bit about technology transfer, because this is, in the old days, it was export controls were very much focused on items, physical items, things of that nature. But now technology actually is much more important in the control of export controls and the enforcement of the activities, and really where some of the danger is. So technology can be released and is treated as an export when it's made available to foreign nationals for visual inspection, exchanged orally, or made available by practice or application under the guidance of persons with knowledge of the technology. So there's a lot of ways you can share technology. There's a lot of ways an export can happen. You could certainly send an email overseas to an entity outside the United States. That's an export. You could share you could share blueprints. You could have a non-US person in your office looking at a set of blueprints, and that would be an export for purposes of what we're talking about. So some examples here that we see quite often, especially when we're doing internal investigations and other issues, shared sites, shared databases that have non-US persons that have access to the material in those databases. That can be an exchange or a release of technology. Plant visits, campus visits, research facility visits. If non-US persons are touring the facility, then it's entirely possible that there could be an exchange, or it could be a release of technology that's controlled during that visit. So the idea here is to really get a sense of how broad the controls are here. As you can see here, there are two main export control regimes. There are other ones as well, but these are the two that we're going to be focusing on. They're the ones that get the most attention. The first here is the Export Administration Regulations. They're administered by the Department of Commerce, Bureau of Industry and Security, BIS. The others are the International Traffic and Arms Regulations, commonly referred to as the ITAR. Department of State actually oversees these with the Directorate of Defense Trade Controls. So the idea here is, and this is of course an oversimplification, but military items are controlled under under the ITAR, military space satellite. And dual use items or commercial items that have a more sensitive use or protection are usually controlled under the EAR. So you're going to find more civilian applications, more commercial applications in the EAR. ITAR is going to be much more defense oriented. We're going to focus more today on the EAR because that's just what comes up more. And frankly, the ITAR is a little bit easier, at least in concept, because it's much more black and white. This next slide, though, I want to show kind of the scope of what's controlled under the EAR. So as I mentioned before, there's these key concepts. This law applies when there are certain activities which are considered to be an export. So it applies whenever there's an export, re-export, transfer, or deemed export of items that are subject to the EAR. And these, as I mentioned earlier, they're not just physical products. It applies whenever things are sent that are software or technology. And again, technology is a little bit more of an amorphous subject here, but it's controlled as well. How is something subject to the EAR? So how is something actually subject to these export controls? Well, they cover all items in the United States, all US origin items, wherever they're located. So if there's a US origin item that's sent overseas, it's still controlled. And then new shipments of that are also controlled. It controls certain items that are made outside the United States if it incorporates enough of a certain controlled type of US origin content. And it can even apply, or they can even apply to items that are made outside the United States if they're made using certain controlled US origin technology or software. So there's a lot of different ways that something can come within the scope of these export controls. And this last point that's bolded is really a key takeaway here. The export control regulations, and this is the EAR and the ITAR, they follow the items. So they apply to all people. They're not limited to US persons. If a person in France has an item that is subject to the EAR and they want to send it to somewhere in Russia, and that's going to be one of those re-exports that we talked about. And it's going to be an issue that you're going to have to check to see, are there any export control concerns? So the export controls are set up as a licensing scheme. It contains certain restrictions and limitations, but the way that it works is you basically apply to the US government. You see if an exception applies, or you apply to the US government to get authorization to make the transfer that you're talking about. So licenses are required in certain instances. They could be required based on the type of item and whether it's controlled or not, and where it's going, so to certain countries, and different countries have different levels of control. They can also be controlled or require a license for exports, re-exports, or transfers of items to or designated for specific countries that are designated for reasons beyond just the export control requirements. Here I'm talking more about sanctioned or embargoed countries. There can also be a license requirement if these items are sent to certain people, persons, or entities. And this would be certain categories of entities and people. Think here military end users, or entities or entities that are on the entity list. They can also be controlled and require a license if they're being sent for specific end uses. All this is laid out in the regs. I know it's all very complicated, but the takeaway here is to think about, okay, I've got this item. I want to send it outside of the United States or to a non-US entity or person. I need to check the country. I need to check the embargoes. I need to check the actual entity, the person or entity that's receiving it, and I need to check the use for it. All of those are different ways that a license can be required for specific items. Again, I'll get to ITAR in a second, but for ITAR, it's real simple. If you're sending it out of the United States or to a non-US person, you generally need a license. There's a thing for Canada, but it's actually a little bit more complicated than most people think. For the EAR, most things leaving that are controlled by the EAR actually don't require a license, but it's a sliding scale, depending on how it's controlled, the level it's controlled, and the different reasons for control that apply for it.
So Grayson, I've got a question related to that. In the event an export license is required for a particular activity, how long does it generally take to receive an export license, and how much does it cost?
Sure, and that's going to differ a little bit for EAR and ITAR, but for the EAR, and again, it will depend on the complexity of the item and where it's going. how it's controlled. But the BIS tries to be pretty efficient in the licenses that they give. So it can take a couple of weeks, can take up to a month. It depends on if it's a particularly sensitive item, like more of a 600 series item, then they have to get input from other agencies, and it could take longer than a month. ITAR, again, a sliding scale, I would say 3 to 4 weeks there. And it all depends as well if you're trying to get like a TAA or a MLA in place, which are different types of agreements, it can take longer. Those TAAs are actually pretty common in collaborative research, but it can take quite a bit longer because of all the different requirements that go. But I'd give yourself a couple weeks at least for BIS and up to a month for ITAR as we go through. And again, COVID slowed everything down, but so other folks' experience may vary there. All right. So let me spend a moment here on the entity list. The entity, and if you get into international trade and international trade restrictions, I hope you like lists, because there's a lot of lists out there, and the government loves lists, and you'll need to learn how to master and understand how these work. This is one that's very particular to export controls. It's a restricted list that contains names of entities outside the US that are subject to additional restrictions under the EAR. In fact, in most cases, this is not true for every case, but in most cases, a person cannot export, re-export, or transfer any item subject to the EAR to any entity that's actually designated on the entity list. Now, the entity list is specific to those entities named on the entity list, but if you're sending to a related company, or if there's other red flags, you've got to do some diligence and make sure that there's no transshipments or other red flags that suggest it may be ending up somewhere it's not. Entity list has become much more important these days. It's being used a lot more. There's a dramatic increase in the use of it to designate entities for a wide variety of reasons. In the past, it was used more for entities, companies that had a history of violating the EAR. It's being used a lot now in the current tensions between the United States and China for a lot of different issues. It could be participating in human rights concerns that are going on. It could be for surveillance activities. It could be for other concerns. So entity list is something much more important. And again, it's one of those things you want to check when you're sending something overseas. Make sure that the recipient is not on the entity list, or if it is, make sure you're following all the required steps. All right, so as I was mentioning earlier, the EAR applies to items that are designated. This is where what I'm showing you here is taken from the Commerce Control List, the CCL. And the CCL is a part of the regulations that spells out the different items that are actually controlled under the EAR. If an item is identified, and you'll see if you go in here, and they're very technical, the regulations are very technical, and you'll see they're divided up into the 9 categories here. But basically, you want to look to see if the item that you're going to be sending is described under one of these regulations. And if it is, then the regulation itself will give you what's called an ECCN, which is an export control number, or export control classification number. And you'll see under that particular heading how it's controlled. And then you'll take that particular entry and those reasons for control and look at the country chart. And you'll actually see 4 different reasons for control. Different countries have requirements for licenses. So you go through all those steps and you can find out, does this particular item need a license to go to this particular country? And the steps that you go through here really do require sometimes some engineering assistance or some technical assistance to work through them. And the good news about this is that there really is an effort to limit the controls, and this is mostly how it's done. The items are described in fairly good detail, so that the regulations are not misconstrued to be too broad or broader than they need to be. The other thing on the right side here, it's divided up into systems, or really products, test or machinery equipment, material, software, and technology. This is important to understand because these categories, we're not just talking about end products here. We can also be talking about equipment that's used to make products, software that's, software that can be used to make products, or encryption software is controlled as well. So there's all these different categories you need to check as you go through here. So let me spend just a minute or two talking about the ITAR as well. As I mentioned before, the ITAR applies in the military context. But you do need to think about it a little bit broader than that. It's military space satellites. It controls defense articles, technical data, again, so think technology, and actually defense services, which is a little bit different from the EAR, because the EAR does not control many activities. The ITAR does actually control activities to a much greater extent. Here, though, again, I'm oversimplifying it greatly, but if an item is either made, customized, designed, modified for military use, then oftentimes it's going to be controlled by the ITAR. There's been a great effort here recently to try and pull things back from the ITAR and maybe put them more in the EAR. It's called export control reform. And that has happened in certain instances, but you should view it as kind of a cautionary tale if you see DoD funding, or if you know that something's being used in the military, especially if something's being customized for use in the military, that you want to check the ITAR and see if it's controlled there or not. Oh, and as I noted a second ago, generally a license is required for all exports, deemed exports, transfers, all of that to all countries, except in some cases, Canada, or a few other exceptions as well, but those are the main ones. So the defense articles that are controlled, very similar to what I just showed you on the commerce control list, there's a US munitions list that contains descriptions. Sometimes these are positive descriptions of items that meet certain categories and certain levels of control, certain levels of performance. And then there are other items and descriptions on the USML that are more categorical in their approach. The technical data, again, very close to what I was talking about earlier with technology. It's information that's required for the design, development, production, all the other terms there in the middle box. So really think of something to make or really understand or get into the inner workings of these defense articles. And then defense services, as I mentioned earlier, these actually go to activities versus items. And it can be assistance relating to these defense articles, technical data, or military training in and of itself is controlled under the ITAR. So there's an arms embargo in place, or several arms embargoes in place actually, and these intertwine with the ITAR, so that if you are looking to try to get a license under the ITAR to send a particular item controlled under the ITAR to certain countries, if it's under an arms embargo, it's very unlikely that you'll be able to get one. And there's also another important distinction in the ITAR, which is that there is a mandatory disclosure obligation if you have a violation of ITAR that involves certain what are called prescribed countries. Most of I just have including China here in parentheses because that's where we see this come up the most. All right, so exemptions, and it's actually probably should say exceptions and licenses. These are very important to understand. As I mentioned earlier, the export controls are built on a licensing permission-based system. There are certain exceptions and general licenses and specific licenses that apply. So if you're in any of these categories, in general, you're allowed to send the item or export it without running in violation of the law. So exceptions are certain categories of activities that actually describe in the regulations that certain activities are allowed or certain exports are allowed. We'll talk about a few of them, but some of them involve sending them to certain friendly countries, certain types of items, temporary exports. You'll actually see in that commerce control list, or that ECCN, it'll indicate whether certain exceptions are allowed for certain items or not. General licenses, this actually comes up more in the sanctions we'll talk about in a little bit, but you can see it with export controls as well. These are basically descriptions of activities that the government says, if you fall in these categories, then everyone has a license to send this particular item to this particular destination. So a general license, you don't need to take any further action other than to make sure you qualify under the general license, and then everybody can use it. a specific license, let's say you go through and you find that, oh, I've got an item, it's controlled, I want to send it to this country, and I've done all the steps here, and I see that there's a license required. Well, that's not the end of your journey here. You can actually go to the government and ask for a license. And as I was saying earlier with John's question, it takes a few weeks to get a response back, but you can apply for a license from the government. And if the government comes back and says yes, they'll usually put some requirements in there with the license, but as long as you follow the requirements of the license, then you're allowed to send the item overseas. So oftentimes working with university or research compliance officers, if you do run into a situation where you'll need a license, you work with those individuals to help you apply for that license so that you can move forward. And here I wanted to take a moment here to talk about some of these concepts, because this, at least in practical experiences, this is where I've run into some issues, especially dealing with professors and other folks at university-sponsored research programs. There's a lot of terms here that can be very confusing. And as we were talking about in the introduction here, there are forms you got to sign, there are documents you got to read, there are different types of provisions and representations you got to make, and a lot of them intertwine, and it can be very confusing to know which one applies when. But products, items can be controlled under export controls, even if they're not marked. And this is true even if you get them from the government or from a contractor that you would expect has a lot of experience in export controls. It does not change your obligation. If you have an item that is export controls, it's export controlled whether it's marked or not. And in addition, companies, entities, individuals can create export controlled material. If you create something that fits the descriptions on that Commerce Control List or that US munitions list, then it's controlled at that point, whether the government made it, whether you made it, whether a government contractor made it or not. So you've got to be very careful about those concepts. There's also oftentimes a lot of confusion as to security clearances and classified information. Many times I've been working with folks in a sponsored research program, and the response back we'll get is, well, it's not classified, so we don't need to, I know we don't need to worry about that. I've worked on classified matters before. I know what I'm supposed to do. Well, that's great, but that's a completely different concept, and it's not export controls. You can definitely have export controls apply to a project that is not classified. In fact, that's very, very common. And to take it even a step further, things that are classified are generally considered ITAR controlled under the very regulations that apply. So it's really important not to confuse these concepts of security clearances and classified materials and export controls. And then finally, and this is something that's happening more and more these days as there's more of a focus on cybersecurity, but cybersecurity requirements and protections, they involve distinct categories with their own terms. Folks are seeing more CUI covered, controlled unclassified information, and then for the DoD covered defense information. These are a different category, and they have to be protected under cybersecurity requirements, but that doesn't mean they're export controlled. Export controlled items are a category of CUI and CDI, but the terms are not interchangeable. So really the takeaway here is that just make sure you're focusing on export controls when you're asking the question about export controls. Don't try to use any shortcuts using these other regimes. It can only lead to confusion. And if you hear somebody else trying to use these shortcuts, you should be a bit wary as we go through. All right. So now we're going to talk a little bit more, dive a little deeper into some of the weeds about research settings and what concepts that we just talked about are going to be most important here. So we're going to focus on these particular areas here: foreign materials, published items, fundamental research and educational materials, and patents, and really mostly on the first three we've got here. So as I mentioned earlier, even items that are made overseas outside the United States can be controlled under US export controls. there's a de minimis analysis that applies in this particular instance. So if the non-US made item incorporates bundled, incorporates software or is commingled with the item, then you have to look at the value of the US part, the controlled US part, versus the value of the whole item. And if they exceed certain percentages, then the item will be subject to the US export controls, and you have to, and when it's leaving that country, you have to worry about, or going to a non-US person, you have to worry about all the stuff that we just talked about. Usually usually the percentage is 25% as a general rule. For embargoed countries, it's 10. And then for a lot of specific scenarios, such as more highly controlled items, it can even be 0%. So even just one small part that's US origin could still cause something to be subject to the EAR. So incorporated is an important concept to understand here. It can't just be that you snap stuff together and then all of a sudden you've got to worry about this. Incorporated has to be essential to the functioning, customarily included, and that they're exported with the item. Bundled, the software, there's specific rules that apply for software as well. This really came up quite a bit when computers were first being exported a lot, and there was the question of, well, what about the firmware on the computer? What about Windows? What about all that stuff that they put bundled with the computer that you don't necessarily want on your computer, that comes with your computer? And these are the issues that come here. And you can imagine that this is also the effort to close a loophole, because people could try to avoid some of the export control requirements by commingling something, a US part, with another part that was made overseas, and trying to get that to to fall into the categories here. That's why you've got this incorporated test. ITAR, different, very different actually. There is no de minimis rule there. It's a see-through rule. A system that incorporates an ITAR control part or component becomes subject to control under the ITAR. There are certain nuances to this rule, especially when you're dealing with things such as printed circuit boards and other stuff like that, but it's very fact specific. I did get a question that I think is actually fairly relevant here. Are there any scenarios that open source software could be controlled under export control? The answer to that is yes, although it would, the general rule is that open source software is not under export control, and that's because of, as you'll see here at the beginning here, the published items. So we'll talk about that in a second. But the answer is there are certain scenarios in which you could have software that could be controlled under the export control rule, and I'll talk about that in detail as we go through here. But let me wrap up with a direct product here. This captures, and I won't spend a lot of time on this, but it is something that people should be aware of. This rule captures certain products made outside the United States when they're produced using certain controlled technology or software. And so this will apply, this usually applies in a concept of national security controlled technology or software. And think about the idea of, okay, somebody's got the blueprints, the specs, the schematics to make something that is controlled for national security purposes. If you just send that tech outside of the United States and then they start making these items, wouldn't it be a problem if we couldn't control those items that are made using US origin software or tech? And that's what this rule is designed to control. But it is designed in a way that it tries to control only certain product and not go broad, because if it goes very broad, then where does it end? So here it's a fairly complicated test, but just know, I think the takeaway here is that if there's an item that is particularly sensitive overseas that's made using US software or technology, you do want to go through this test and see whether the item is controlled or not under the US export controls. And I will note, although not go into detail about it, that there are much broader versions of this rule that can apply for specific entities on that entity list that we talked about earlier. All right, so exceptions to the scope of the EAR. So I talked about earlier, you can be subject to the EAR if you meet all of these or if you meet one of these different prongs and went through them. Well, one of the ways that you can actually be kicked out of the scope of the EAR and ITAR for that purpose is if something is published or made available to the public without restrictions on further dissemination. And this is what gets to that open source question we have here. Think in this instance, the old examples used to be something published in a library or something that was described in great detail at a public conference or something that is available to everyone who can come to see it. Those items, because they are so freely distributed, they are not controlled under the export controls. Open source software, oftentimes can fall into this category, but you've got to make sure that you meet the definition here. So if you have open source software that you get, but then at that point, there are restrictions on disseminating it, there are royalties attached to it or something else, then you have to really ask yourself, are we meeting the definition of published? I think you do start from a position of, oh, this should fall outside the scope, but then you want to make sure you look and see what are the actual rules that govern the further dissemination of this piece of software. And one of the things I wanted to note here, it's something that could actually be a different 1 to 2 hour presentation, but if the software involves encryption, there can be very specific and very complicated rules that apply, and encryption is treated as differently for software than other software under the EAR, and if it's incorporated into a new item, and this is true even for other pieces of open source software, if they're incorporated into a larger piece of software, then you have to look at that larger piece of software and see whether it is controlled. So just building a piece of software from a whole bunch of different pieces of open source software doesn't mean that that new software is not going to be controlled just because it came from a bunch of open source components. You actually have to look and examine the new piece of software. Okay, so another exception to the scope here is fundamental research. And this is one that is really key to universities and research institutes. The definition is here is that basically technology information software that is, arises during or from fundamental research or research in science, engineering, or mathematics, results of which are published and shared broadly within a research committee, and for which there are no restrictions for proprietary and national security reasons, are not within the scope of the export controls. We're going to talk about fundamental research in just a second because it's widely misunderstood, but it is a very important exception that applies in this context. And then just real quick, this last one, technology information software that appears in patents or in open patent applications, those are not export control. People often ask, well, how does it get there? If it's controlled in the first place, there's actually a process you go through. Many of you probably know this, that when you submit information to the patent office, it's actually reviewed for national security before it is made open at that point, and then it can go through a different process if it does involve national security controlled material. So let me spend a second here on fundamental research. So the definition seems fairly straightforward and fairly broad, but in application, it can actually get very confusing. And so what I've put up here is some information that BIS has actually published that helps to understand the different contours that apply in this space. So, and the biggest one is you have to look to see what restrictions are being put on the outcome of the research or on the methods used during the research. So proprietary research, that's easy. It's the #1 way. If that's the case, then if that applies to your research, then it's not going to be controlled. Government-funded research that specifically restricts the outcome for national security reasons, and a lot of sponsored research-sponsored program projects involve this, is not going to fall under fundamental research. And then I have a couple of examples here where you actually have the fundamental research exception in application. Just take a scenario of university-based research that has restrictions on publications of scientific and technical information resulting from the research. That would not, the fundamental research would not apply in that instance. And then here, this last example is one that actually I think demonstrates a commonly misunderstood part of the fundamental research exception. Collaborative research, where you have an agreement involving proprietary technology and someone has to sign an NDA. You sign an NDA that, okay, we're getting this technology to use during this project. This project's going to be fundamental research, but we've got this technology or this equipment that's controlled. Great, you may have a fundamental research project at that point, and it may be that some of the information and technology that comes from this project is not controlled because it meets that fundamental research definition. But that doesn't mean that this technology or this equipment that you signed this NDA from all of a sudden qualifies for the fundamental research exception as well. You could still need a license at that point. You could still need to develop a technology control procedure for that particular product. So, a lot of times the fundamental research exception or exemption gets misunderstood, and it basically, folks may believe it applies to all of the activity that occurs on campus or in a research concept or a research setting, or that just because you have one aspect of a project that involves fundamental research, that somehow subsumes or takes over the rest of the project. It's just not the case, and it's an area that you need to specifically pay good attention to, and it probably gives folks like John nightmares at night. So I see he's got a question for me.
I do, Grayson. Thank you. In academia, we are seeing federal sponsors impose some very specific disclosure and reporting requirements on our research activities. For example, some Department of Energy labs are requiring that they approve foreign persons assigned to work on research projects that would otherwise ordinarily qualify as fundamental research. Do those requirements threaten the designation of that research as fundamental research? And if so, does that mean we're going to need to obtain export licenses for foreign persons to work on those projects?
It's a great question. And there's not a black or white answer to that. So, I'm a lawyer, so my favorite words are "it depends." But yeah, it's a great question. And the DOE, and this actually relates to another question that came in as well. The DOE, they have their own export controls that apply under 810 of their section, and those are actually separate from the EAR and ITAR ones we talked about, but are also very important. It really goes to this second bullet at the top of the slide here. It does requiring the pre-approval of individuals who are working on a particular product. Does that qualify as government, a government restriction based on national security reasons? And I can see arguments both ways that yes, it would apply, because why in the world would they be asking about this unless they were trying to restrict it for some reason? But you still, again, it may not actually affect the outcome of the research. So this could be one of those situations where you actually have activity similar to this bottom bullet, where certain of the activity could be export controlled or controlled for other reasons, but the research itself has no restrictions. And the outcome itself has no restrictions at the end of the day. So you could still have export controls having a practical effect on the work that you're doing for the project. But at the end of the day, the report you generate or the products you generate may not be export controlled, because it could still fall under the fundamental research exemption or escape from the scope. It's going to be interesting to see that situation play out, because you would imagine if DOE is worried about this, from a foreign person perspective, that they may be taking the view that the output is controlled. So one piece of practical advice with this particular issue is have an open and continuing conversation with the folks at the agency you're working with about this particular issue, because it's so much easier to get these things resolved up front than it is at the end of the day. You've done the research and now you're just trying to figure out what you can do with it. A big example of this is under the ITAR. There are certain parts of the U.S. munitions list that will apply almost a catch-all restriction to the results of DoD-funded projects if you don't get built into the contract that the project itself is not ITAR controlled. And so you want to have that conversation up front to find out what's the government expectation, because going back and trying to get a commodity jurisdiction about that after the fact is so much more difficult than if you do it up front. So.
Great. Thanks for that, Grayson. Before we move off of DOE, I do want to touch on this question that was posted in the chat. I have a student from India working on a DOE project on nuclear materials. I was told that the student must have a DOE authorization per Part 810 of Chapter 10 in the CFR Code of Federal Regulations. Can you explain what that is?
Sure. Well, I can at least give some clues. So again, as I mentioned a second ago, the DOE, they have their own export control regulations, and that regulation under 810 is the section I was referencing before. So this is basically, it's the DOE saying, hey, we think there may be a deemed export situation here. If you have this student from India who's applying, or who may be working here, then you'll need to look at the the restrictions that apply. And have a discussion with DOE about it. It may be that they may want to take the position that the work that's going to be done is controlled under the DOE export controls, and may require that you apply for a license, or may say that that individual can't work on it because they would not grant a license. But it's very similar to what we've been talking about for the EAR and ITAR. It's just under a different regime for the same concepts. All right, well, let me continue to march through here. Deemed exports, I want to spend just a little bit more time on this because this comes up a lot in a research setting, because it's really easy to find yourself a deemed export scenario. You have US persons working on a US project in the United States, and then you have a non-US person join that project. You've got to be concerned about deemed exports at that point, and check to see, is this technology or is any of this equipment that we're using, would this require a license to go to the country of the individual where the non-US person is from? And if so, then you might have a deemed export control situation, and you need to look and see whether any exceptions or licenses may apply in that instance. One thing I want to note, and this is something that's come out a lot here recently, it's not US citizenship under export controls, it's US persons. And US persons includes citizens, it includes lawful permanent residents, it includes TPS status, asylum, asylees. So check the definition and make sure you're asking the right question. I am not a labor or employment or discrimination lawyer, but you want to ask the right question about US persons and not US citizenship, so you don't get into hot water for those other reasons. And then I also want to note a few things that BIS has stressed about this deemed export situation, trying to add a little bit of clarity to it. So technology, we've been talking about technology a lot, and when it's controlled and when it's not. Not all technology is controlled. If you get a handbook for your lawnmower that you're going to use outside, that usually wouldn't be considered controlled technology for that lawnmower. And that's going to be the same concept here with more sensitive items. Technology is controlled only if it's required for the development, production, or use of items on the Commerce Control List. And it's specified as well in the control list. And note that the word use there is in parentheses because it's defined in the export controls. And it's more than just how to use something. It's got to go into refurbishment, and repair, and a whole lot of other items that must actually be met before it qualifies as use. And these next examples here give a little flavor to that. BIS has provided a note on required technology, saying that if the information is not in the public domain, therefore subject to the EAR, and does not enable achieving or exceeding the control parameters of the end item, then the technology is likely EAR 99. It's a complicated concept, but it basically boils down to, you got to look at why something's controlled, and it's usually controlled for a particular reason. Like a computer is not controlled because it's a computer. The computer is controlled because maybe it's a quantum computer. And so the technology to make just a normal computer would not be controlled, but the technology to make a quantum computer would be controlled. And so that's what the language there about achieving or exceeding the controlled parameters of the end item, that's where you want to focus. And this last one is really important in a research setting. Being taught how to operate or actually using equipment is not necessarily going to be the exchange of information of technology. It can be. It depends on what the training is and how it goes. It can be detailed enough that it would be a problem, but as a general rule, just being trained on how to operate lab equipment and actually operating lab equipment, not going to be a deemed export of technology concerning that equipment. So I'm going to go through these next ones very quickly. These are other common exceptions that apply in export control, but these next ones, TSR and TSU, apply when you're sending technology or exporting technology or software. TSR is really technology that's restricted for certain reasons, meaning for a higher level. And basically, the idea here is that there may be an exception that applies if you're sending this technology or software to a friendly country, what the U.S. considers a friendly country. You'll see references to country groups. Basically, the export controls divide up countries into different groups and have different rules apply to those countries. TSU is more common. This is basically technology unrestricted, and it allows the exchange of technology and software in a lot of different areas, including the release of technology and source code in the U.S. by U.S. universities to their bona fide or full-time regular employees. But again, this doesn't mean all technology and software can be given to employees. You have to look at the actual entry and how the technology or software is controlled to see if this exception would apply. But for a lot of them, this would apply, and you would be able to share it with your own regular employees. So this is one of those exceptions. It's important, and actually for all the exceptions, it's important to read them and apply all the details, but this is one that may come up. I have actually had a lot of situations with universities in which the issue is a scholar, a professor, a researcher is traveling, even to sanctioned countries. And that really, one takeaway rule is to use a clean laptop program, wipe everything from your laptop. Don't take anything that's controlled on your laptop over there. But there are certain exceptions that can apply. Baggage is one of them. This just allows you, if your computer itself is controlled, then this exception may apply. And then this last one is the temporary exception, a temporary export. And again, these are different for EAR and for ITAR. This one I'm talking about is EAR. And it allows the temporary export of certain items overseas. It allows the temporary export of beta test software. This comes up a lot when you're traveling to conferences. And there are other exceptions that can apply there as well, especially if you're presenting at a conference. But keep these in mind. These are things that, again, just because you have a situation where you might encounter a limitation, that's not the end of the question. It's not the end of the issue. But you've got to make sure you're working with your compliance officers and your folks and who understand these rules to navigate them. All right, so
Grayson, if I can jump in very briefly before we move off of the EAR and ITAR, do have a couple of questions, one of which I believe is as follows. Can we share experimental data from a fundamental research project that is self-funded and involves international collaborators overseas?
I'm trying to make sure I understand the question. So experimental data, I mean, if something is the result of fundamental research, then it would not be controlled under the export control. So at least for that purpose, then it seems like this would be okay and would allow that sharing of research. The only question I have is about that word experimental. I'm not certain I completely understand it. Because if it's going down a road where you don't know whether there are going to be restrictions on publication of the data or not, then you'll need to be careful. and you can't share something and then later claim a fundamental research, share something claiming a fundamental research exception, and then later, put restrictions on publication and things of that nature. So if it's truly fundamental research, then yes, I would think you could.
Okay, great. And can you expand a bit more about patents and how patented technology is not part or not subject to the EAR?
Sure. And again, I'm not an IP lawyer, so I can't get into too many details there. But my understanding is there is, and Jay, maybe he can explain later. I don't know, but there is a process that you can go through if you do have material technology that you're trying to patent that is controlled for national security purposes, that it gets routed to a different division in the PTO. And that you at that point work to preserve your patent, which is under seal at that point and not published. And you can still get the protections, I believe. Again, don't quote me on that. I'm not an IP lawyer for what you're seeking to protect, but that prevents it from being exposed and exported in general, and it prevents it from falling into the category of, it prevents it from falling outside the scope of the EAR by being part of an open or published patent or patent application, because it's submitted under seal and maintained under seal.
Okay, thank you.
You bet. All right, so we're going to talk a little bit about sanctions now. Again, I'm not going to spend a lot of time on sanctions. It could be its own presentation, but the two intersect so much, and especially in a university setting and research collaboration setting, that I think it's important to talk about. This nifty little slide shows visually some of the sanctions issues that we deal with. I think most people are familiar with the fact that there are sanctions that apply to countries. Here we've got the shading of the different countries or different ways, different levels of sanction. You can really have three levels of main sanctions. Comprehensive sanctions, here think Iran, Cuba, North Korea, Syria, and Crimea, 5 countries there. U.S. persons are really cut off from having any type of transactions, exports or imports with those countries. You've got enhanced sanctions, here really Venezuela and Russia, and some other countries are getting close on those where it's not a comprehensive ban, but the ban is broad enough that you really have to take a lot of steps to see, are we dealing with a sanctioned party, maybe by categorical sanctions as well. And then you've also got extraterritorial sanctions, which we'll talk about in a little bit, that actually are not limited to U.S. persons, not aimed at U.S. persons. But the first are the primary sanctions. Primary sanctions, again, those are the ones that we're talking about the most. They apply certain types of prohibitions to U.S. citizens and permanent residents and U.S. companies. Also applies to U.S. branches, and for certain instances, it can apply to foreign subsidiaries of U.S. companies. They can also apply when U.S. Origin or U.S. controlled goods are being exported or sold or re-exported, and they can also apply related to just certain activities as well. One of the things I want to get across here as well is that sanctions are not limited to just activities within the United States. They can apply to U.S. citizens wherever they're located. As I mentioned, foreign branches. They can apply to U.S. individuals or companies if part of the activity occurs in the U.S. and part outside. Employees of U.S. companies, no matter where they are, could bring in a sanctions problem. And then foreign entities and persons where there is a nexus to the United States. That's a big issue, and it comes up a lot, and it comes up in ways that people don't really think about it, because they think, I'm outside the United States, I'm not dealing with a U.S. person necessarily. Why do I need to worry about it? It can be because there's U.S. controlled items here, or it could be that there are persons who are physically located in the United States, or it could be that you're involving U.S. denominated payments, in which case you're actually bringing a U.S. financial institution into the transaction. So with the sanctions, what is usually prohibited? Well, they're very broad. You're usually prohibited from importing or exporting from the U.S. Or to the U.S. and the sanctioned country, or relating to the sanctioned individual or entity. And this includes services. So if you're providing services to someone, or if you're receiving goods or receiving services from someone in a sanctioned area, that's where these issues can come up. And they're so broad, they also cover transactions or dealings with individuals and entities in sanctioned countries or that are specifically sanctioned. Actually, I just realized I forgot one thing. Let me go back one second. The third category here that I should have mentioned earlier was actually targeted sanctions. So you've got comprehensive, moderate, and then you've got targeted sanctions. And actually, that's all the light blue ones you see here. And those involve lists. Again, I was talking earlier about the entity list. Well, sanctions are administered by Department of Treasury and OFAC loves its lists too. And so they have the SDN list and other lists as well. These targeted sanctions, usually the way that you find out who you're dealing with is sanctioned is you have to go to these lists and screen against these lists to see whether one of these restrictions may apply to your transaction. It's more likely that there are entities, there's usually more entities from these countries that have that are shaded in blue here, but that's not always the case. You can have SDNs pretty much anywhere in the world. I'm sorry about that. Okay, so going back to what is prohibited. So we talked about importing, exporting, and transactions. There are also other indirect activities that are prohibited under the sanctions. Facilitation is a big one. Again, a U.S. person cannot do cannot participate in an activity indirectly by facilitating that activity. So this happens, for instance, I think the easiest example here is referral. If I got a great business opportunity from someone in Iran, but I couldn't do it because I'm a U.S. person, I couldn't refer that to somebody else because that would be considered facilitating. If I'm an international business and we get that great opportunity from the Iranian company, but it has to be approved by a U.S. person in my company, and I can't do it because that U.S. person, involving that U.S. person will be a problem, I can't change my internal procedures to remove that person from the process. So evasion and avoidance are very similar. You can't do activities, basically you can't get too cute. You can't do activities that would cause the indirect violation. Secondary sanctions, just real quick. These are sanctions that have been passed. These again are rather modern development. These are sanctions that are passed that are directed at non-US persons. And these are much more politically oriented. And they authorize a lot of sanctions. Most of them are related to cutting off an entity or an individual from the U.S. financial system. But think here of things of if a foreign entity is engaging in a specific activity involving Iran's petroleum sector, the U.S. government at that point could use the secondary sanctions to go after that non-U.S. entity and cut that non-U.S. entity off from the financial system in the U.S. because it doesn't like what's going on with that non-U.S. entity engaging in that activity. So what does all this mean for a research setting here? I think there's three main ways, and we've seen these come up in practice. Sanctions may limit or restrict U.S. persons in academic collaboration from sharing information with researchers from certain countries or in support of certain industries. Even if no U.S. persons are involved, sanctions may also limit the scope of research and academic projects involving U.S. origin technology, software, or funding. So it introduces these complications, especially, almost think of sanctions here as export controls plus. If you've got folks who are on these lists or from these countries, not only do you have the export controls you got to worry about, but you've got this additional layer of restrictions as well. And then secondary sanctions could also come into kind of big picture items for research collaboration or research activities, and can limit what activities an entity or groups may want to participate in.
Grayson, Quick question. So recognizing that there may be differences between the various sanctions regulations, for example, between Cuba and Syria sanctions, are there any generalizations you can make with regard to how export controls and sanctions in particular may affect students in a classroom setting? For example, do we need to be worried about having an individual from Iran in our class?
Sure. Really good question. And it also highlights the fact that these sanctions programs are all different. So what may apply in an Iran program is going to be different from the North Korea program, is going to be different from the Cuba program. So it can complicate things. And both export controls and sanctions can complicate what happens even in a classroom setting, even apart from just a research setting. I had a very practical issue, this applies to a situation that came up in an actual matter where a classroom involved a certain lab component that required the use and coding and development of software that was actually controlled for encryption reasons and for other reasons. And there were foreign students who were going to be participating in this classroom. And so there were real questions that came up as to, in the agreements that the professor signed and that the school signed to get access to the software, they had to agree not to provide it to individuals outside of the United States or non-U.S. persons. And so there was a question of, does this, would there be a requirement under export controls to have them actually see the code and get into the software? This is not just using the software, but to get into the software and work with that. And then there's a layer on top of that for, say, Iranian students. And they're actually, in this case, this came up with an Iranian student who was coming to the school, enrolled in the school, and wanting to participate in this particular class. And it was a situation of looking at the sanctions. In this particular scenario, you also look at the visa that the person has and whether the visa authorizes certain activities and whether certain exceptions apply. But even participating in the class in this particular situation, and in other situations we've seen, you've got these issues that can come up and that can arise. And I tell you, the export controls and sanctions are almost in a natural tension with universities and education facilities. And we've seen this actually going back decades before, even before me and Jay were involved in these types of activities. A lot of the early exceptions grew out of compromises that were reached between the regulators and the U.S. government and universities and education institutions. Talking about the natural conflict between open expression and free research and non-discrimination issues, and that's how a lot of these issues have developed over time. There is just a natural tension here, and it's something that really does affect how these particular issues play out on campus, and it can make it difficult to get buy-in for a lot of these different requirements. But it's so important that folks understand what's going on, because once we get understanding and buy-in, then we can start to work and understand the contours of it and make sure that everyone has an understanding of what they can and can't do. All right, so let me take a spin here in the next 10 minutes or so through just this next section here, which are recent developments and trends going forward. I don't want to spend too much time here because I know you guys have talked about it before, but everyone knows about the China initiative here. It's been going on for a while here. It does focus on prioritizing perceived threats from China, and there's been recent prosecutions of professors in this area. And again, I mentioned earlier the use of the entity list and other restrictions and trading restrictions and placement on lists. And while not necessarily part of the initiative, we've definitely seen an uptick in the activity and application of export control restrictions that are specific to China and deemed exports relating to folks who are Chinese nationals. There's also the trade secret targets, but that's a different issue, and I highlight that more here to distinguish between the two. There's actions here that show that export controls are part of the China initiative. Looking at this potential exposure of sensitive technology is definitely part of the priorities that are out there. I put this here and I want to highlight it because really foreign influence is a different issue, and I just want to highlight how it's different from export controls. Foreign influence and the prosecutions that have been happening here really focus more on the identification of funding or potential influence over certain activities or research, conflicts of interest as well, and research integrity. Many of the forms that have to be filled out or completed in connection with sponsored research require disclosure of different funding, different activities, different past activities. And these may overlap with export controls and sanctions, but the focus for foreign influence is really more on disclosure and transparency versus a prohibition or a licensing requirement. So it's just a different concept, and foreign influence issues can come up in projects or activities that have nothing to do with export controls and are really more about identifying different areas of foreign influence here. And so you see the enforcement actions that are coming up here are not violations of the export control laws or the sanctions, but they're more false statement or focusing more on incomplete or misleading statements. So trends going forward, we do think that the trade secret prosecutions will likely increase. Again, this is just our perspective from my perspective from my practice, not necessarily anything that's been specifically identified. I think the prosecution of researchers will likely continue. I think that there's definitely been a focus in the U.S. government in identifying that as part of the China initiative, that the view is that there are attempts to obtain and receive and illicitly extract sensitive information through research. And so I think that the activities will continue there. And I think the regulations in the area will continue to increase as we go forward in this Department of Education initiative I'll talk about in just a second. One of the issues that has come up here recently is the military end user restrictions and the military intelligence end user restrictions that now apply to China. In the past, they only applied really to Russia and Venezuela, but now they've been expanded to China. And this is really because there's been a priority identified in the US government about civil and military fusion in China. And so there's a real idea now that, or concern identified by the US government that the Chinese government and Chinese companies are taking technology, information, materials that have been normally received in a civilian context and then applying it in a military context. And there are a lot of rules that have been changing and that have been put in place to put more controls up as a result of this. There used to be an exception, the CIV exception, and other looser requirements for civilian end uses, and civilian end users of technology and export controlled items. But now there, at least in specific countries, China, Russia, Venezuela, and China was just recently added to this regulation. There are now restrictions put in place on specific items, although they're very broad categories, that are being sent to Chinese military end users or for any Chinese military end use. There's a list that's been created, the Chinese military end user list, the MEU list, although that list is not exhaustive. So even if the entity that you see or that is relevant to your transaction is not on that list, that doesn't mean that this prohibition doesn't apply. You still have to look at the situation as a whole. Similar concept for the Chinese or for the military intelligence end user list. Again, it's targeted at certain countries. China is one of them. And this is a broader prohibition in that it applies to all items subject to the EAR, but it's a narrower set of end users and end uses that really are focused more on military intelligence as opposed to broad military end use. And I'll just make a note that the definitions of military end user and military end use in this rule are very broad. There have been attempts to try to clarify what it means, but in practice, they can be very difficult to actually figure out whether the prohibition applies or not. March you through this. There's also this we've been talking about for a while. Congress and Department of Commerce have highlighted the need to identify emerging and foundational technologies. The idea here is that restrictions will be placed on these technologies. This was really put in place quite a few years ago to really kind of protect the defense industrial base and also other sectors that are deemed sensitive. And the idea is that these new technologies, or these new technologies as far as emerging and foundational technologies, will be identified, new restrictions will be placed on them, and they will come into play as far as restrictions and triggering review in the CFIUS context, which I'll talk about in just a second. There's been a few emerging and foundational technologies identified. I think most people have thought there would have been more, and there's actually been some significant pressure from Congress, even the last administration and the current administration, trying to build and put pressure on commerce to move faster in implementing these new controls. It's not easy. I mean, I have a lot of sympathy because in this area, deciding what is controlled is, again, it's that balance we were talking about earlier about what's dangerous. Do we want to overly restrict our businesses? Do we want to prevent, open research from going through? And adding on top of that, you've got the question of unilateral or multilateral restrictions. Oftentimes, the export controls are put in place because of various multilateral treaties or multilateral actions, conventions that are in place that say, yes, as a world, we're going to control these particular items. Usually the controls that are put in place as part of a multilateral control are stronger than a unilateral control because you've got more countries participating. But oftentimes it's very difficult to get a multilateral control in place because countries may have different interests, perceptions. Certain items may be made more in other countries than in others. And it's much easier and faster to go unilateral, especially to respond to rapid changes in technology. So there's a lot of tension that comes into play with this. This last piece on this slide here highlights that semiconductors is still going to be a major focus going forward. Again, there was the supply chain review that was ordered by the new administration. They identified a lot of things. There have been several laws that are passed or in the process of being passed, in which they're really focusing on trying to control not only the U.S. technology, but also trying to make sure we secure the supply chains of our allies. This is one piece of legislation here. There are actually multiple pieces of legislation that are pending right now that have to do with China and that involve export controls or controlling sensitive technology in one way or the other. The Innovation and Competition Act, the ICA, is one that's pretty comprehensive, to say the least, that's currently being considered. But the idea here, especially with this particular one, is it shows the broad idea, the broad efforts that are being considered of controlling a significant amount of sensitive technology or IP going forward in the future. And frankly, right now, restrictions on China especially are one of the very few bipartisan issues that are currently going on in the US government. And again, I want to note, this is not a one agency issue. We talked about I know you guys have talked about the DOJ before with the China initiative, but again, as we talked about sanctions with Treasury, anti-money laundering, FinCEN, Commerce Department with export controls, immigration issues of DHS, and the SEC with public companies, and that also the Treasury's been working on that as well, certain restrictions. Last topic I want to hit, and then we'll get to some questions, is CFIUS. And I do a decent amount of CFIUS work, but CFIUS doesn't usually come up for universities, which everyone can be thankful for. I think it's a pretty challenging area that is difficult to maneuver. But just real quick, the concept of CFIUS is that there's a committee of multiple agencies in the US government that reviews foreign investments in US businesses to see if those investments present any national security risks. And if they do, then CFIUS has the power to block a transaction, or actually recommend the president block a transaction, or force a divestment. In practical terms, how that usually works is the committee will work with the parties doing the transaction, and they'll enter into certain mitigation agreements in which they'll agree in certain ways to protect the issues that CFIUS concerns itself with. It overlaps a good bit with export controls, because one of the areas, one of the things that can trigger the CFIUS review is if a foreign investor comes in and acquires or looks to invest in a U.S. business that is engaging in certain critical technologies, which would include export control materials. I said this is something that most universities have not had to worry about yet. That reason I'm mentioning it here is because some of the pending legislation now would bring the joy of CFIUS to universities in a very specific way, but it would expand the scope of CFIUS to include any gift to an institution from a foreign person, or the entry into a contract of higher education with a foreign person if, and there's certain categories here on the slide, you can see the value of the gift exceeds a certain amount. The gift relates to research, development, or production of critical technologies, and there's access. You may read these different factors and think, well, that's a pretty specific scenario that may not happen all that much. I can tell you, in having very similar parameters apply to businesses, a lot of work goes into when there's a proposed, in that case, investment or acquisition, as to whether these items are triggered or not. And the CFIUS consistently takes very broad interpretations of the regulations and laws that apply in this context. I would imagine if this gets passed, it would be very similar. So if this does get passed, I would expect there will be, there will be significant amount of work and activity that goes into, where these gifts come up or these contracts come up. So with that, let me turn. I think we still have some time for questions, if that makes sense.
Yeah, great, Grayson. Thank you very much for that. I've got a couple of, we've got a number of questions in the chat that we'll get to. Before we go to those, though, I'd actually like to ask Maggie Lewis if she would mind answering a question that may or may not be in her area of expertise. So Maggie, in previous sessions, you've stated that you feel the focus on China in the China Initiative is problematic, and there was a very good article in the Chronicle of Higher Education recently where you were quoted saying something similar. Grayson noted in his presentation that many of these export controls are based on multilateral treaties. Are you aware of any attempts on the world stage to try to address research security, foreign influence through multilateral treaties rather than on a country-by-country basis?
Well, first, thanks. This was hugely helpful. I mean, I am a lawyer and a law professor, so I also love it depends, but I appreciate the attempt to try to give some more concrete descriptions. I also do a lot with international law. I think international treaties can be great. I don't know of an effort with respect to that, and I would be hesitant, partially because it's very slow and cumbersome to create a multilateral treaty, and there can be a lot of words that sound good, but the devil is in the details. So I think our efforts are at this point probably better focused on our domestic response, and particularly getting to that point about Congress, where it is true that one of the few bipartisan issues is being tough on China. And yes, China is a near peer competitor. I've spent my whole career basically criticizing Beijing's human rights record, but how do we respond to those legitimate concerns? And so one thing, and I know we have other questions, but I would love, after all this description, to to maybe also hear a little bit of a prescriptive approach as we try to, as the United States, find this balance between protecting research and economic and national security, but also giving space for international collaboration and for legitimate business. That sweet spot is very hard to hit. How are we doing? Can we kind of get a report card? And going forward, in addition to having, you mentioned about the open conversation with agencies, is there more that could be done with, for example, kind of a no action letter approach that we see with like the SEC, or where people who want to engage in activities can get more comfort up front before diving in, that if they pursue a certain path, they will be, without, ironclad, they'll be safe, but at least make it so the kinds of collaborative, productive activities that will benefit the US can continue without the level of fear that we're seeing today, that there might be enforcement actions, including using the criminal law.
Yeah, and just to follow up on that last one, which I think is a great idea. There are certain activities that you can get advisory opinions from Commerce and from OFAC, and you can get the specific licenses, but there are practical difficulties for both of those. The timing being a huge one. Advisory opinions can take quite a long time, and sometimes you just don't get them. And oftentimes the specific licenses, you have to be so specific in them, not to borrow the phrase there, but that it doesn't lend itself to broad collaboration or research activities. And I think what, for this to be effective in getting more of a safe harbor approach, there has to be a willingness, I think, to engage in broader parameters where you have maybe trusted actors participating in a program. And I think, honestly, the biggest issue is staffing to a large extent. I know our, BIS, OFAC, DDTC, they're great folks that work there, but they're overworked. And, that's one of the biggest issues, is just trying to get responses from them when they're drinking from a fire hose, quite often. And every time, I was talking with John about this earlier this week. Every time you see all the executive orders and Federal Register notices and everything coming out, that means all the international trade lawyers around the world are very busy. It also means everybody at BIS and OFAC and DDTC are very busy as well. So it's you've seen more resources being passed, in the latest budgets and in the laws that are going forward. So I think there is some work being done to address this. But so many of these laws that we're talking about basically say, hey, send this to BIS or send this to CFIUS for review, and it's a lot. And it's easy to pass a law saying we need to have more control over all of this, much harder to pay for it.
Great, thanks, Grayson. We are fortunate to have Jay Bratt, the Chief of the Counterintelligence and Export Control Section at National Security Division of Department of Justice, with us once again. Jay, given your responsibilities at the Department of Justice, I'd like to ask you to comment on how export control regulations factor in, if at all, to the Department of Justice's China initiative and the cases that have been brought so far, or are they intended to address completely separate concerns?
So certainly national security cases that involve violations of export control or sanctions are significant, and those that involve the PRC are significant. As I said at the forum, that was the webinar that focused entirely on the China initiative. If you look at our various areas of responsibility, and if you look at export control and sanctions, the China cases over the years, at least since I've been there the last 6 years, have consistently made up about 20 to 25% of the cases that we do. The largest number of export control and sanctions matters relate to Iran, and even a significant part of our China practice, our China cases, also relate to Iran. Hong Kong and China have become transshipment points to Iran. We also see that North Korea uses front companies in China and actors in China to engage in prohibited US dollar financial transactions. And so to the extent that we are looking at China using intermediaries to acquire restricted technology, export control technology that it could not otherwise obtain, or companies and persons in China who are on the entity list, again, using cutouts to acquire goods on their behalf. We see that somewhat, but not to the extent that we see that happening in Iran. So that isn't a big emphasis of the matters that we have brought. I also think from a threat perspective, as I've said previously, what we look at in terms of the China Initiative cases, and really what the original emphasis of the China Initiative was to be, the economic espionage, theft of trade secret cases, that those have been on the rise. Regardless, even if we'd never had an initiative, we would be doing more cases because that activity was increasing over the last several years, and continues to be a steady source of cases that we have. And as I've at least have a theory, as I've explained before, that if you look at China's goals, particularly say Made in China 2025, and its desire to become independent in about close to a dozen key sectors of the economy, and looking where it is in its development as a sort of newly emerging developed country, it doesn't have the wherewithal as sort of a strategy to accomplish all those goals without there being theft. And that is really more of the emphasis. And we don't see as much, though we do have cases, and we have, I think, look at some recent cases of restricted power amplifiers that went to China, or the Xi case that we had in Los Angeles, where Mr. Xi was recently sentenced, which involved, again, controlled items going to China. But it is not on the scale that we see with respect to Iran and its efforts both to get U.S. origin commodities and technology, and to make use of the U.S. financial system in order to do business with others throughout the world.
Thank you for that. So Grayson, I believe this question may be for you. If a company registered in Hong Kong or the Cayman Islands, but is operating in mainland China, how would such a company be treated with regard to export control regulations?
Yeah, that's a good question, and it actually it brings up some of the issues that we talked about, and where it can get very complicated. Because if a company is registered, I mean, a company will be considered basically a national or a person of the country where it's incorporated, where it is activity, where it's acting. However, if it's operating in China mainland, and you're sending an item to like a Cayman company in China, then you really have to focus on where it's going at that point, which is going to be mainland China, and look at that. You also would need to be concerned. I mean, let's say it's an Iranian company operating in China. You also need to be concerned, well, is this also going to Iran through China, or is there a chance that it's going to be replicated and that version is going to be going to Iran? You basically need to treat all of these different aspects that you're talking about as suspicions or red flags to determine, are there any of these that we think are going to be a problem? Now, the question often comes up, like let's say you have this situation, and a license would be required to go to China, would not be required to go to the Cayman Islands, and you send it to the Cayman Islands. Then you've got to look for clues or suspicions that they're just getting it in the Cayman Islands and then going to be sending it to China. This comes up quite a bit in Hong Kong, and situations with Taiwan. That's why there's actually, as Jay was saying earlier, there are areas of transshipment or diversion that are known to be, Singapore, the UAE, are known to be, areas where this happens more often than not, and you got to be a little bit more suspicious as a result. But frankly, if you're sending stuff, pursuant to certain exceptions or pursuant to certain licenses to, like, Hong Kong, not anymore. It used to be Hong Kong was treated separately than China. That's not the case anymore. Hong Kong is basically now treated the same as China. But if you're sending it to, say, Taiwan, you can have to go and obtain things like letters of assurance and other types of documentation in which they agree not to send it to China or to other countries in what are called country group D. So to kind of put a point on it all, because I know that's a lot, and I kind of talked about a broad scope there, but you really got to look at where the item's going physically, and then who you're sending it to as well, to see all these other risks, or to see if I send it to an Iranian person in China, is that going to be considered an export to China and export and Iran? It absolutely could. And so that's why you need to look at those particular facts and answer that question. I think Kylie has his hand up very politely there. So,
well, thank you, Grayson, and thank you for the panelists giving wonderful explanation and this webinar. The question I have is, in the research community, and at least up to now, principal investigators and the research team decide what to open source a piece of software, what to open source the design of a piece of hardware, at least it's in computer science or computer industry. So the question is whether the government, in terms of export control, will control what to allow to open source.
It's a great question. Let me give my answer, and then maybe Jay can jump in as well. If something is open source and it's released open source, then it's going to be published, and would normally, if it's truly open source and there are no restrictions on dissemination, then it's not going to fall within the scope of the EAR or ITAR. However, there are certain situations where I know that the government can apply unilateral action if there's something that is so sensitive that is being released that it would present a threat, in which they can step in and prevent that from happening. So Jay, maybe I'll turn that over to you for that particular portion.
No, I mean, I think actually, Grayson, you're more conversant in this than I, because that's more of a regulatory issue. We get involved when, and I think it's important that a criminal violation of the export control and sanctions laws requires a knowing, intentional violation of law, that you sense that you are aware that either the person that you're sending it to, or in the deemed export researcher context, that the collaborator or the student that you're having working on the project is somebody who's prohibited from working on the project and prohibited from being exposed to the technical data, and you do it anyway. We are, what we concern ourselves with are those who are intentionally seeking to violate the law. That type of what you've just described, sort of a very technical situation, again, if somebody steps in and says, you cannot export this, we've made that determination, and you go ahead and do it anyway, that's a very good proof of willfulness. But sort of negligent violations, and I'm sure, Grayson, you do a lot of work on the administrative side, where there's a much lower burden of proof for the Department of Commerce or Treasury or State to impose administrative penalties. That's where a minor slip up could still lead to some sort of penalty, but it's not the sort of conduct that's going to get us involved and lead to a criminal prosecution. Yeah,
well, fair enough, and absolutely. It's useful to draw the distinctions between the different agencies and goals of the agencies there. So the general concept is that if you publish it, if you do make it open source, that it will not be within the scope. However, there is often the question of, if you've got something that the government would want to control, was there anything that was controlled that was used in the process of making it, and does it actually contain any components from that? So you'd have to look really very hard at whether there was any aspect of that. You can't take what was controlled and then just make it, just publish it, excuse me, openly at that point, because there's certain restrictions in place on that. Although that is the subject of litigation that has been going on back and forth over the last few years. and I do know that there are certain unilateral ways that the government can step in and they can classify certain information, and they could certainly come in and classify information that is deemed too sensitive, whether it's being open sourced or not. Think of like the plans for a nuclear weapon or something. Just because you tried to publish that and make it open source, the government's not going to let that happen. And so that could come into play. It's a sliding scale, though. And one other point I want to make, Jay's absolutely correct. The DOJ and the NSD is looking at criminal enforcement of these laws in which intent and willfulness and knowledge are important. OFAC, BIS, DDTC, it's strict liability. It's a very different standard at play there, and it's a difficult one to wrap your head around, because it can apply administrative and civil penalties in any of those instances if there's just a violation. You don't have to have knowledge. You don't have to have intent. It is strict liability. Now, the way that it shakes out is that if there is an enforcement action, or if there's a disclosure or something along the lines of a violation, you tend to show what happened in discussion with the government, and explain what precautions you had in place, if you didn't have knowledge, if somebody else was the bad actor and maybe they stole something from you, or if there was activity where even though you had great controls in place, there was negligence or there was a mistake. You explain all of that, and the government takes that into consideration, and they apply what are considered aggravating and mitigating factors in coming up with a result. And if there's enough mitigating factors, then it can result in a no action letter or a cautionary letter. If there's enough aggravating results, then it can result in a penalty or debarment, or worst case scenario, referral to Jay's department. So.
Well, thank you for the answer. Most researchers, my impression is that don't really know what is controlled, what's not controlled. For example, if someone working in the area of encryption, and the typical style is that you publish some research result, then the implementation of the software, you open source it. But since you don't know what's under the category of expert control, how to avoid being prosecuted or being violate the law. I mean, does that mean that such a researcher would have to, before you open source the software, you have to even just publish? Would you have to ask some organization to approve? I mean, in that case, it would make the research community how to operate quite complex. It's difficult to figure out what to do.
Yeah, and I wish there was an easy answer for that, but there is just not, because it's going to depend on the situation and how the software is developed, what components it has, what's the issue at play. I mean, look, if you look at OpenSSL, this is an encryption piece of software that was open source, and it obviously a lot of it was developed overseas, but a lot of it was developed in the US as well, and that was published without action taken by the government. However, I have the feeling that if there was a new encryption method that was developed and that the government felt our enemies could use to hurt us in communications that we couldn't crack, there could be some issues there in trying to make that public or open source. So you'd really have to work through the details and understand, before you do something like that, if it's going to be something very sensitive, you want to have your I's dotted and your T's crossed and make sure that you're being very careful about it.
But again, I would just highlight that what you're describing is not necessarily a criminal violation, even if you get it wrong. We have done over the last decade only one deemed export prosecution involving somebody in academia. Now, maybe that's because there are things that are slipping through, or maybe it's because people like Mr. Jenkins are doing a very good job in the compliance part of universities. But again, our burden is a very high one of showing intentional conduct. And that case was the Roth case. Dr. Roth was a professor at the University of Tennessee, and he was told multiple times that he could not have foreign students working on this project that he was doing that was funded by the Defense Department. And he was told that he could not have an Iranian student work on it, and he had him work on it anyway. And he was told he could not have a Chinese student work on it, and he had him work on it anyway. And then he was told that he couldn't take certain information to a conference in China, and not taking a clean computer, as Grayson advised, he went to China with his computer with the controlled data on it. And he was prosecuted and he was convicted, but he was, again, told multiple times that he could not engage in that conduct absent getting a license to share the technology.
Yeah, good point.
We do have one person in the audience, Shinrong Ren, who would like to ask a question. So. Shinrong, are you there?
Hello, can you hear me?
Yes.
Yes, I just have a quick question about DOC. Recently has I think a senator had a report on the DOC. They had about unauthorized investigation, into its own employees. I don't know if you are aware about that, and do you have any thoughts on the if DOC is going to do internal review, if other department, other parts of U.S. government could possibly do the same thing?
I don't know that I'm familiar with the exact case that you're talking about, but I do know that there has been, and I believe there have been some BIS individuals who've been investigated and have been identified as being, active in certain wrongdoing before. It is actually not that uncommon. It happens from time to time, and agencies investigate their own actions through either an inspector general, or it could be, that the DOJ can investigate as well if there's criminal activity involved. So, there are instances where individuals in the government could get caught up to one of these issues. I'm certainly not aware of any widespread concerns or widespread investigations involving DOC personnel or anyone else who's involved in the export control enforcement or regulatory areas. So I hope that's helpful.
Can I just jump in? Is this the commerce situation where they were allegedly reading emails of people of Chinese descent? Is that as far as the misconduct being the way that it was, people within DOC were putting certain employees under the microscope and investigating them because of factors and characteristics that were deemed inappropriate? Is that the question?
That's right, yeah.
So with just this, I would say that if you haven't seen Eric Lander, the president's science advisor, just within the past week issued a statement, part of which was talking about how as we think about research security going forward, because there's no doubt there's a lot of conversations that need to happen about what changes need to be made. But that part of it is making sure that policies do not fuel prejudice and xenophobia. And this is a long-term challenge. And I say this as, I'm in Taiwan now. I'm very aware of threats emanating from the PRC party state. And I think we're going into, and very much in and continuing to be in a time where competition and perhaps worse between the US and China is going to make research security something that we're going to have to work on. So I welcome those statements by Dr. Lander, and the Biden administration is saying a lot of good things, but now to quote our vice president, now we got to do the work, right? Because it's easy to say we don't want to fuel prejudice and bias and xenophobia. It's much harder to make sure that those principles and values are really permeating into all that's done in the government.
Thank you.
Okay, any final questions from our panelists? Well, Well, if not, I believe we are nearly out of time here, but I want to thank Grayson Yeargin for the donation of his time to speak to the Asian American Scholars Forum on the topic of how export controls may impact research activities. I thoroughly enjoyed this evening's conversation and hope that each of you did too. I also want to thank the panelists who joined us, as well as sponsors of tonight's session, the Asian American Scholars Forum and the co-sponsoring institutions. In my humble opinion, I think the work this organization is doing to raise awareness about the concerns of the Asian American research community is very important. Each of you have a voice, and I think it's imperative that you make that voice heard. Forums like this serve a vital role in educating the public as well as government officials about how these policies may have unintended consequences. And I think it's important that the members of this group continue to educate the rest of us about this unique industry called academia. It's our ultimate goal to generate knowledge and share it broadly for the betterment of mankind. And I think by taking part in these AASF sessions, you've recognized that your role in educating the American public is not limited to the classroom. And so for that, I thank you. Finally, a special thanks to Jianmin Gao and Nancy Chen and all of the other volunteers who helped organize this session. We really appreciate the generous donation of your time and energy to these sessions.
And let me just say thank you as well. I really appreciated the invitation to speak. Thanks, John, for helping to coordinate this. I really appreciated that. And thanks for all the great questions. I know there's a lot of interest, and it's a very complex area. And again, trying to get in as much as I could today was a challenge, but I appreciate everybody's patience with it. And yeah, absolutely, really enjoyed coming here tonight.
Wonderful. I guess our thanks to all of the speakers and panelists for such a insightful educational webinar, and the video will be made available. So it will have a long-lasting impact to the Asian American community and overall and beyond. So thank you all very much. I guess this concludes today's webinar, and I'll see you in future webinars.